Okay, well, thank you, Colleen, for that introduction. It's great to be on the campus and great to see you again and Jack again. Thank you very much, and thanks to all the students and faculty and others who came today. So my topic today is the so-called new speech wars on campus. I'm going to do this a little bit differently than I've done in the past. My views on free speech on campus are very conventional and I think very boring. And rather than dedicate a lecture to articulating those views, I thought I'd do something a little bit different and try to make a few points by reviewing the history of speech controversies leading up somewhat to where we are today. Now, in terms of the so-called new speech wars on campus, well, I suppose that could be summarized, quite quickly. And I'm not saying anything new here. The old speech wars typically pitted the right against the left, trying to suppress the left, communists and socialists and anarchists mainly. And it was mainly the government against individuals and groups. Those are the old speech wars leading up to the modern time. The new speech wars, especially those on campus, are somewhat different. The new speech wars pit really the left more against the right. It uses new categories, such as hate speech arising out of identity politics. And it's not the government, typically, that's trying to silence speech, but on the college campus, it comes not from government, but from faculty, administrators, and student groups. So in that sense, the contemporary speech wars are much different than the speech wars that some of us experienced, some of us older folks experienced when we were growing up, say in the 1950s, 60s, and 70s, when it was the right against the left and it was government suppressing individual speech. So this is somewhat different. Now, my view is that free speech might not be the right metaphor to describe the problem, because I'm not sure that it's very useful on a college campus for people to be running around incoherently screaming at one another and saying whatever comes off the top of their head or issuing epithets against one another. But I do believe in robust speech on the college campus. Every important issue that roils a society should be discussed and debated on the college campus. Probably every articulate point of view that's backed up by rigorous reasoning and fact should also be presented on the college campus. If some people don't like it, they don't have to attend, or they can show up and ask questions and try to enlighten themselves about the matter. So that's kind of where I stand. So this idea of suppressing speech in the name of hate, I don't care for that idea. One reason is I don't know what hate speech is. And it's very difficult for anyone to define it. And it's one of those categories that has a tendency to expand with experience. So what was commonsensical speech a few years ago can morph through the political process into hate speech today. So I'm very uncomfortable with that. I'm going to try to go into that and try to explain with some historical references as to why that's the case. So let me go back to the beginning. Well, this is not actually the beginning. This is some of the more recent controversies. Condoleezza Rice was disinvited, former Secretary of State, very distinguished person, was disinvited from a couple of campuses, including Rutgers in 2014, mainly because of her role in the war in Iraq. It didn't even have much to do with hate speech, just had to do with her association with a particular controversy, and I don't think she even intended to speak about the war in Iraq. But if Condi Rice can't speak on a college campus, I don't know really who can from a more conservative point of view. There's Charles Murray at Middlebury College a couple years ago. Everybody knows about that because shortly thereafter Charles Murray came here and he was allowed to speak, and though with some controversy. I think Charles Murray, people should listen to Charles Murray and hear what he has to say. People think that Charles Murray is really writing about race, but he doesn't really write about race. Charles Murray, the case Charles Murray is making is that in the post-war period, the United States bifurcated itself into a highly meritocratic class society, with colleges and universities, the leading ones, becoming very meritocratic, in allowing students to come in on basis of achievement and test scores. Men and women, young men and women gathered on these campuses. They met one another. They married one another. They went and moved to wealthy suburbs. They worked on Wall Street or very high status jobs. Their kids went to private schools or elite public schools, and they segregated themselves off from the rest of society. And because of their positions, they had an outsized influence on the way society developed. That's what Charles Murray is really writing about. He wasn't really writing much about race. Now, if students had heard that argument, they'd begin to understand how Donald Trump got elected, because Donald Trump got elected in protest against that development in American society. So you don't have to agree with Charles Murray, but I believe he has something worth hearing and would benefit students in terms of understanding where our country is. This is what happened on Yale University campus a few years ago. You're aware of the Halloween controversy. I happened to be on the campus by accident that day, participating in a forum on free speech on campus that had been planned 6 months in advance. And some of the students who were protesting the Halloween issue tried to break into our auditorium and break up our program on free speech on campus. I thought that was an irony that somebody tried to break up a conference on free speech on campus. But that's where we are. That kind of expresses somewhat where I think we are with this. In the attempt to suppress hate speech, we're going to suppress a lot of other valuable speech in the process. So now let's go back to the beginning. That's the death of Socrates. So you all know the story of Socrates. Socrates went about Athens, raising questions about the gods of the city, the religious beliefs of the city. He didn't ridicule them. He raised questions. That was what he said he did. And he ran into difficulty with the authorities in Athens, as one would do when one raises questions about the most fundamental issues that guide a society. And they tried Socrates, and they found him guilty. And they asked Socrates what punishment he should get. And he said, you should give me a free meal and support me for the rest of my life so that I can help the city of Athens. They didn't care for that. They decided he should be put to death. He could have escaped if he wanted to. He decided not to. He couldn't live without philosophy, and he couldn't live outside of Athens, so he died. This is the trial of Jesus. You all know that story. And Jesus obviously was asking for trouble when he went into the temple of the rabbis and said that he was suggested that he was the Son of God. That was not a politic thing to say in that environment and in that circumstance. And he was put on trial first by the religious scribes and then in front of the Roman emperor. They were under Roman occupation at the time. And he was beaten when he articulated some of his views. And he made a very good statement. I've always thought this is a very good statement that Jesus made in his trial, which was, if I'm wrong, show me where I'm wrong. If I'm right, why are you beating me? I always thought that was a very good statement. And it stands up very well over time. But in terms of Socrates and Jesus, the lesson I would draw from this is that there's always a regime in place. There's always a fundamental set of assumptions that are precious to a society or to an organization. And if any individual or group of individuals transgress the assumptions of that regime, they're likely to get into some trouble. And that's what happened to Socrates deliberately. And of course, the story of Socrates is well known throughout the Mediterranean at the time. Jesus knew all about the story of Socrates. Maybe to some extent emulated it. But in both these cases, they transgressed basic assumptions of the regimes in which they lived. And we know what happened. So one of the questions we can ask ourselves when there is a free speech crisis, free speech did not apply in this era because nobody believed in free speech in ancient Athens or ancient Jerusalem. But you could ask yourself, what are the assumptions of the regime that are being called into question that bring down the wrath of some groups to try to keep the speech from going forward? That's one of the questions that I'd like to ask about the college campus in terms of the speech crisis. What is the regime that is being threatened? So this is John Milton. Probably our conception of free speech dates from the Reformation, from the Protestant idea that every individual has to educate himself on the fundamentals of religion and decide for himself his own theology. That means everybody has to be able to read, think, reason for himself. And of course, this is after the publication of books. So the Protestant idea does begin to emphasize to some degree free thought, free speech, and free publication of books. Now, it didn't do them much good because right after Milton wrote those words, England erupted into horrible civil war, and Milton was on the side that sought to suppress the speech of Catholics in England in that civil war. So one kind of lesson that I get out of this is that sometimes groups that believe in free speech when they're not in power are not necessarily advocates of free speech when they get into power, and that's one of the enduring problems with this issue. The English Civil War led to the English Bill of Rights, which talks about free speech, especially freedom of the press, not so much speech, and many of the other elements that are incorporated into the U.S. Constitution. I've listed a few of them there: petition the king, free speech and debates on the floor of Parliament, excessive bail. You can see that from our Constitution. So it was out of this experience that the American Constitution and the American Bill of Rights begins to bubble up from that experience. And that is the First Amendment to the Constitution of the United States, ratified in 1791. 3 years after the Constitution is ratified. So it's interesting, of course, that says Congress shall make no law. A lot of people thought at the time that this is totally redundant. Why do we have to have this in our Bill of Rights? Because everybody knows Congress can't make any laws that deal with speech. It's way beyond the authority of the U.S. Congress. State governments, of course, were doing all sorts of things to limit speech and expression. But no one thought the federal government had this authority. You know, one thing about this is that the First Amendment in America has become a kind of a totem. By that I mean, it says Congress shall make no law, but basically we've applied that principle across the board almost to everything. So that it's not that Congress can make no law, but everyone has a wide berth for speech, independent of the laws. So that applies to colleges, universities, local governments, everything. As that concept has evolved. But no sooner had we passed the Bill of Rights than the Congress, in the battles between the Federalists and the Democrats and the Jeffersonians, and the controversy over the French Revolution and the battle between France and Great Britain, then the Federalists passed a Sedition Act in 1798 that banned false, scandalous, and malicious writing against the government, the John Adams administration. And many Jeffersonian newspapers were shut down, their proprietors convicted and thrown in jail under the Sedition Act. There was never any Supreme Court case challenging the Sedition Act. It was done away with by Jefferson's election in 1800. When he pardoned all those people who were convicted and charted a different course. The Sedition Act, I don't believe has ever been repealed. It's a dead letter in the law, but I don't think it was ever repealed. And so Jefferson, this is Jefferson's gravestone if you've been down to Monticello, so those are the things he's proudest of: Declaration of Independence, the Statute of Virginia Religious Freedom, and the father of the University of Virginia. That's Jefferson. You know, our great apostle of free speech and free expression. That's Thomas Jefferson. And these are some of the things he said about it. It does me no injury for my neighbor to say there are 20 gods or no God, it neither picks my pocket nor breaks my leg. His point was that words are basically harmless. They don't do you any injury. If somebody wants to talk, let them talk. It's just air. And then he says down below, the University of Virginia is dedicated to the freedom of the human mind. Tolerate any error so long as reason is left free to combat it. That's his vision for the University of Virginia. It's a kind of an expression of our view of the First Amendment. Now, one thing I'd note about Jefferson's comment about speech neither picking his pocket or breaking his leg is we don't seem to believe that anymore. We think that speech represents a weapon, and it actually does hurt people. Jefferson didn't think so. Jefferson said if you don't like the speech, ignore it or confute it, confound it, prove it wrong. That's Elijah Lovejoy's abolitionist newspaper attacked in 1837, killed by a mob. This is Alton, Illinois. Abraham Lincoln makes a speech about this, saying that the rule of law is not safe as long as things like this happen. Elijah Lovejoy was an anti-slavery newspaper owner and published tracts periodically denouncing slavery. And for that, his newspaper was burned down and his printing press tossed into the river. The regime at that time said that it was dangerous to attack slavery. And that was the predominant view at the time in the United States in the 1830s, that it was dangerous, disloyal, whatever, to attack the institution of slavery. So embedded was it in American society. That's Preston Brooks in 1856 attacking Senator Charles Sumner of Massachusetts on the floor of the United States Senate. So Charles Sumner, an abolitionist senator from Massachusetts, made a speech on the Senate floor attacking slavery in very strong terms and also denouncing a fellow senator who happened to be the cousin of Preston Brooks. Brooks took revenge upon him. The senator on Sumner, when he was sitting at his desk on the Senate floor, almost beat him to death on the Senate floor. And it took Sumner 7 or 8 years to recover before he returned to the Senate. This was one of the things that showed that the United States is on the way to a civil war. This is going to happen again, by the way, on the floor of the United States Senate in your lifetimes, not too far in the future. That's Lincoln and Douglas debating on the campus of Knox College in 1858 in their famous Senate duel. I put that up mainly to suggest, to show that this could happen on a college campus in 1858. These very deep problems, thousands of people showed up and listened to Lincoln and Douglas debate slavery, mainly in the territories, and the meaning of the Declaration of Independence on the campus of Knox College. Well, we know what happened next. Civil War, Lincoln being assassinated, and that's the kind of thing that happens when societies fall apart because they no longer have any consensus as to what they're all about. John Stuart Mill, of course, you all know John Stuart Mill as the great apostle of individual liberty. He makes 2 points in On Liberty. One, an individual should be left free to himself or herself as long as the things he's doing affect only him or her. Society has no right to interfere with an individual as long as the things that he or she is doing don't bother anybody else. I guess a corollary to that is consenting adults should be able to do whatever they want. The other thing is that there should be a wide berth for freedom of expression, because every point of view has to be tested in the so-called marketplace of ideas in order to figure out their worth. He who only knows his side of the case knows little of that. You don't know your own views until they're tested by someone else and you're forced to defend them. Now, John Stuart Mill in On Liberty is really defending the, what would you call it, the dissenter in society. John Stuart Mill was very concerned about the kind of oppressive atmosphere created by the universal acceptance of Christianity. And he knew that there were a small number of people who disagreed with that and were afraid to express themselves, he being one of them. And he was very interested in allowing a wider berth of dissent against the dominant point of view in England at the time or in any society. So he wanted to defend the dissenter. I think a question that might be raised, I mean, some people suggest that his main goal was to dissolve Christianity. I don't know if that's true. But a good question that can be raised is, what happens when the dissenters get power? When the dissenters rise to power and say the Christians or members of any other religion are now in the minority, will they stick to that same point of view and allow a wide berth for freedom of speech? That's again back to the question that I raised. When people are out of power, they're very much in favor of free expression. They take a different view when they rise into power. The jurisprudence on free speech in the United States really begins in a serious way with the passage of the Espionage and Sedition Acts of 1917 and 1918. In the wake of World War I, Woodrow Wilson and the Congress passed these laws, which I've underlined the chief points. It's a crime to cause insubordination, disloyalty, mutiny, et cetera, or to interfere with the draft or the military of the armed forces in the midst of this war. Sedition Act prohibited disloyal, profane, scurrilous, abusive language about the United States government, its flag, or its armed forces, or caused others to view the American government or its institutions with contempt. Now, this is what I was saying before. The original early speech wars were really about government suppressing individuals, most of them on the left, who opposed the war, and this is really an early case of this. I think that the Sedition Act of 1917 was a kind of an update of the Sedition Act of 1798, 130 years earlier. These are some of the people who were prosecuted. Most of them leftists. You see Eugene Debs, prominent socialist. Bill Haywood on the right, prominent union leader. John Reed, prominent socialist, supporter of the communist revolution in the Soviet Union. All tried and convicted under the Sedition and Espionage Act of 1917 and 1918. You know, the first real case that came up, and some of these people, Schenk versus U.S. in 1919, challenged the convictions under the Sedition and Espionage Act. It wound up in the Supreme Court, and the Supreme Court upheld the convictions and upheld the constitutionality of the Sedition Act, and with an opinion by Justice Oliver Wendell Holmes, where he articulates the so-called clear and present danger doctrine. In other words, the government has a right to suppress speech if it has a view that it will lead to a clear and present danger that it has a right to suppress. In this case, interfering with the military in the midst of the war. So Holmes wrote that opinion for the majority. I included this quotation from Holmes at the bottom where he says, and it kind of reflects Holmes' view of the law. He said, told someone in his court, this is a court of law, young man, not a court of justice. Don't come to the court seeking justice. Come to the court to seek the enforcement of the law. A couple of women protesting outside the White House following the conviction of some of those men, reminding Wilson that the First Amendment says Congress shall pass no law, when, in fact, they've now passed a very draconian law. Now, as I said, with 1919 and the Sedition Act, we begin a 50-year period where the Supreme Court articulates its jurisprudence on the First Amendment. And there's a whole sequence of cases here where they start out with this clear and present danger doctrine, and they evolve, as I'll show in a minute, to a very different place. In Abrams versus the United States, same year, These were some men who were circulating flyers protesting against the U.S. intervention into the revolution in Russia. Again, these are socialists. The United States was sending military assistance to the groups in Russia that were trying to turn back the revolution. And they were issuing leaflets against that, and they were convicted under the Sedition Act. The conviction was upheld, but Holmes dissented. Holmes now takes a different tack, and where he now says that the best test of truth is the power of the thought to get itself accepted in the competition of the market, and that truth is the only ground upon which their wishes safely can be carried out. The only problem with that is, what is truth? That was Pontius Pilate's question to Jesus. What is truth? Now, Holmes would say, well, we don't know. We have a marketplace that will eventually determine that, but unless we can determine what truth is, how can we tell if the marketplace is effective in getting there? But this was a dissent by Holmes, and this kind of sets in motion a different point of view. Now, let me just step back and now talk about the idea of academic freedom on the campus. Here's Charles Beard. Charles Beard, one of the most famous historians of the era, a progressive historian, a liberal or progressive. He wrote a famous book called An Economic Interpretation of the United States, where he suggested that the founding fathers were really acting to defend their property interests. They weren't really that interested in universal rights or individual liberty. It was an economic move. That's been somewhat discredited, but Beard was a prominent historian. Columbia University fired 2 professors who criticized the First World War. And in sympathy with them, Charles Beard resigned in protest from Columbia University here in October of 1917, claiming that academic freedom, a concept which had not really developed at that time, should have protected these professors and their criticisms of the war. This idea is codified then by the American Association of University Professors in 1940, when they, in their bylaws, stated that academic freedom is the freedom of teachers and students to teach, study, and pursue knowledge and research without unreasonable interference or restriction from law, regulations, or public pressure. This is a fundamental statement of the rights of professors and students on the college campus to pursue their studies without interference. These are in the bylaws of the American Association of University Professors. This is a fundamental document which has guided the governance of American universities since that time in the 1940s. I think that's still a statement that is in the AAUP's guidelines. So this is a kind of evolution from the idea of free speech, now applying it to colleges and universities. The common good depends upon the free speech, free search for truth, and its free expression. Here, just a diversion. These are communists and Nazis fighting on the streets of Berlin in 1930. And you could ask the question, well, what are they doing? Well, they're fighting for power. And you could ask the question, well, why do we have these institutions like a Senate or a court or a legislature or whatever? Well, we have these things as alternatives to this. When those things break down, people go out in the streets and fight it out. So when our institutions break down, this is what happens. They went out and fought it out, and we know what happened then. Something different was happening in America. The Supreme Court is now beginning to take a different tack in the 1930s than they took in the midst of the war. You can understand that. In the midst of the war, things are pretty heated. Now in the 1930s, they're a little bit different. So in a very important footnote, I think, to an important case, the Supreme Court says basically that the liberties of the First Amendment are fundamental to a system of ordered liberty. And the Supreme Court will take a very jaundiced view toward any regulation which tends to suppress speech or the press, or the free exercise of religion, or the establishment of religion. These are fundamental to a system of ordered liberty, and the Supreme Court will be very skeptical of any regulation by the states or the federal government in this regard. 1941, Franklin Delano Roosevelt articulates these ideas, the four freedoms, as a central element of America's war aims. So at this point in 1941, Roosevelt was trying to maneuver the United States into the European war against a very strong opposition from isolationists. It had been a tradition in the United States that we didn't get mixed up in European wars. We got mixed up in World War I. It wasn't a good experience. We know it let's not let it happen again. Roosevelt felt that what happened in Europe was eventually going to have a big impact on the United States, but in America, you can't go to war unless you have an idealized view of what you're fighting for. And he set forth in 1941, now this is before the United States is in the war. The United States is not in the war until December 1941. He sets forth his view of the four freedoms. And this was rendered in illustrations by Norman Rockwell on the cover of the Saturday Evening Post. So up in the upper left-hand corner, that's freedom of speech, freedom of religion. Down below, freedom from want, and freedom from fear. I'm not sure what those last two mean. It certainly points to a more positive role of government than freedom of speech or the various freedoms from that we have. But and he says not only that, freedom of speech and expression everywhere in the world. So one of the war aims of the United States, if it ever does get into this war, would be to circulate liberal norms of democracy and free speech around the world. Meanwhile, in 1940, Congress passes the Smith Act, which bans advocacy teaching of overthrowing the government of the United States by force or violence, fine and imprisonment. They're aiming this mostly both at Nazis and at communists who were active in the United States in 1940. That's the Smith Act, passed in 1940. Now, this looks a little bit like the Sedition Act of 1917, 1918, or the Alien and Sedition Acts of 1798. And as the New York Times article says, 11 communists are convicted of a plot and will be sentenced to prison. So I think the idea here is that what is communism? Communism is itself a plot to overthrow the government of the United States by violence or force. That's what Marxism teaches. So as a consequence of teaching Marxism and expressing Marxism, you're guilty under the Smith Act. The U.S. Supreme Court carves this back in the 1950s and 1960s under the leadership of Earl Warren, Chief Justice of the Supreme Court. This is 1957. So in Yates versus the United States, they overthrew convictions under the Smith Act on grounds that advocacy of abstract ideas are protected by the First Amendment. So now you've got this distinction between the advocacy of abstract ideas and advocacy of action. So you can't directly advocate something that's illegal in an immediate sense, but abstractly you can say anything you want under this doctrine. So you could say, for example, that sex with children should be legal. There's nothing wrong with it, et cetera, et cetera. You can articulate all you want in an abstract way. You just can't have sex with a child. That's illegal. But you can articulate it all you want. Many people thought that was illogical. You know, Abraham Lincoln said in the midst of the Civil War that why should I have to shoot a soldier who deserts, but allow a newspaper to publish articles which urges him to desert? That would be, you know, abstract advocacy. But this is the doctrine the Supreme Court is now playing with. Abstract ideas, you should be perfectly free to articulate. It's just when this moves into action for illegal actions that it can be circumscribed by law. Sweezey versus New Hampshire, another very important case in the same term. This is so-called the red term or the communist term in the U.S. Supreme Court under Earl Warren. Sweezey is a socialist professor at the University of New Hampshire, and the state of New Hampshire had a law banning communists from teaching in their universities. And Sweezey was interrogated by the Attorney General of the state, and he refused the interrogation because he felt they're interfering with the things that he was teaching in the classroom. He felt that was sacrosanct. So he refused to comply. He was convicted. And the Supreme Court threw this out again. And under the same doctrine, abstract ideas are fine. Advocacy of particular ideas to do harm, not so much. And they say to impose any straitjacket upon the intellectual leaders in our colleges and universities would imperil the future of our nation. So in our schools and universities, there should be maximum freedom of speech, of abstract ideas. That's the doctrine. They go further, and the state of New York had a law banning communists from teaching. The Supreme Court overthrows this. Again, this is now 1967. The vigilant protection of the constitutional freedoms is nowhere more vital than in the community of American schools. So schools and colleges now represent an area where there should be maximum freedom of expression and freedom from any suppression. This is encoded in the Supreme Court jurisprudence and in the canons of the American Association of University Professors. And then from there into the guidelines for the conduct of people on the college campus. The Supreme Court takes this about as far as it can go in 1969 in Brandenburg versus Ohio. Actually, this involved a law in the state of Ohio banning what they call criminal syndicalism, which is, again, another version of the Sedition Act. But this was in the case of a Nazi. And the Supreme Court threw that conviction out. The line between what is permissible and not subject to control and what we may made impermissible and subject to regulation is the line between ideas and overt acts. So ideas are perfectly free. Overt acts are something that can be regulated. Some people suggest that they found a case of a Nazi for this ruling because they'd made so many cases defending communists that the Warren Court figured that to protect its flank, it ought to defend the Nazi. Whether that's true or not, I don't know. So what I would say here is, in just quick review, you have an evolution of Supreme Court jurisprudence which develops a liberal point of view to a maximum point beyond which it probably can't be taken any further. And the point of view is this, that the individual must be free from the regulation of the state so long as he's advocating abstract ideas and is not engaged in overt acts which may break the law. So this I would call a liberal interpretation of the First Amendment. The individual has maximum freedom against the government and its representatives, and that would include public universities and its administrators and many private universities and colleges to the extent they receive government funds. So with Brandenburg, they take this about as far as they can go, and they can't go much further. There's some elaboration of the doctrine, but that's basically it. All right, so now we have a different development. In the 1960s, something called the New Left arises on the college campus. And they don't like the old left, the communists, because they think they're bureaucratic. And they think that the sources of revolution in the future are not from the working class, but from students and professors. And they see the university as a base for revolution for a lot of reasons. A lot of freedom on the college campus. A lot of young people gather on the college campus. It's an area where a lot of ideas are circulated. So if we can get a hold of the university, we can advance our ideas. This is the idea of the New Left as articulated in the so-called Port Huron Statement. A lot of talk in there about how important the universities are in American society and how important it would be if we could get control over those institutions to advance the ideas of what's called the New Left, not the communist left. And this breaks out on the campus of the University of California in 1964, the so-called free speech movement. Really what they wanted to do, what the protesters wanted to do on the Berkeley campus, was to open the campus up to political activity. It wasn't so much free speech, it was we want to engage in political activity on the college campus. We want to pass out brochures, political material. We want to demonstrate. We want to do all sorts of things of a political nature that they were not allowing us to do at the time. And they did win that battle, and that kind of kicked off the controversies on campus in the 1960s. Not long after this, Herbert Marcuse publishes a book called Repressive Tolerance. And in his argument in Repressive Tolerance, he argues that, hey, free speech really aids the oppressors because they're the ones who can pay for it and they're the ones in position of power to use it. Real free speech means suppressing the speech of the powerful to liberate the speech of those who are not powerful. This is the idea of repressive tolerance that bubbles out of the new left that's gaining influence on the college campus in the 1960s. So we saw an evolution of a liberal jurisprudence with regard to free speech. Now we're beginning in the 1960s to see an evolution of something different, an attack on the liberal conception of free speech in the name of a political movement, actually in the name of tolerance, paradoxical as it may seem. The United Nations Commission on Human Rights, International Convention on the Elimination of All Forms of Racial Discrimination. This was passed in 1965, went into force in 1969. The United States is a signatory to this treaty of the United Nations. There it is. There are the basic points of this resolution passed by the United Nations, signed by the United States with some reservations. So it says that any doctrine of superiority based on racial differentiation is scientifically false, morally condemnable, socially unjust and dangerous, and that there is no justification for this in theory or practice, and that the various states who are signatories to the treaty shall declare an offense punishable by law. All dissemination of ideas based on racial superiority or hatred, incitement, et cetera, shall declare illegal and prohibit organizations which promote and incite racial discrimination, shall recognize participation in such organizations or activities an offense punishable by law. That's the United Nations. And the United States has signed that treaty. So, I think we can see that this is a new tradition that's somewhat developing here in the 1960s, not a liberal tradition of defense of the individual against the state, but something else which proposes to regulate speech in the name of some greater good. This is the hate speech clause of the European Union, passed in 1967, adopted a recommendation on hate speech, which stated the term shall be understood as covering all forms of expression which spread, incite, promote, or justify racial hatred, xenophobia, anti-Semitism, or forms of hatred based on intolerance, including, you can read the rest. That's the European Union in and still in force. And many people have been convicted under these laws. People who've attacked Israel, people who've attacked Muslims, people who've written cartoons, mocking various groups in the European Union. This is not the tradition that developed in the United States. I'd ask this question. Is socialism and communism, why shouldn't that be a hate crime? They're just talking about racism, xenophobia, anti-Semitism, so on. In other words, things that seem to arise from the right. But what about communism and socialism? Why shouldn't they be hate crimes too? This is a comment by R.J. Rummel, a famous political scientist, who's counted up all the people killed in the 20th century by communist and socialist regimes. He adds it up to well over 100 million people. 61 million in the Soviet Union. A lot of them by terror famines in the 1930s and outright suppression. 61 million people, that's a lot of people. Stalin said that one death is a tragedy. 1 million deaths is a statistic. Mao, 55 million people killed between 1948 and 1976 when he died. Also in terror famines and in the Cultural Revolution in the 1960s. Horrendous barbarism perpetrated by the communist government in China. Hitler was a socialist. We sometimes forget that, but he was a National Socialist. We think 21 million killed across Europe in what we call democide, not in war, but by murders by the government. And this one is completely outrageous. This is 1975 to 1979, in the lifetimes of some of the people here. In Cambodia, a country of 7 million people, the Khmer Rouge, under the leadership of Pol Pot, killed 2 million people in a matter of a few years in communal massacres, burying people alive, and mass shootings. This is not long ago in Cambodia. And, you know, in recent years, they've dug up some of these mass graves, but that's an unbelievable atrocity in Cambodia. So the question is, if all these other things that the European Union and the United Nations are declaring as hate crimes, why isn't socialism and communism a hate crime? I just raised the question. So now we kind of begin to move through this new period we're in. William Shockley, a famous scientist, goes to Yale University. He believes that the different races have different IQs, and there's a protest against it. He's shouted down, driven off campus, and as a result, Yale University passes this resolution about freedom of expression on the Yale campus. Basically, a very good statement that there should be a wide berth of freedom of expression on the college campus. This is the so-called Woodward Report, led by C. Vann Woodward, a famous historian. And beginning in the 1980s, we get a series of speech codes passed by college campuses, on college campuses around the country, which wind up in the courts. Here's one from the University of Michigan, where the University of Michigan tried to prohibit any behavior, verbal or physical, that stigmatizes or victimizes an individual on the basis of race, ethnicity, religion, sex, sexual orientation, creed, etc. The federal courts threw it out. Threw it out because the Supreme Court has consistently held that statutes punishing speech or conduct solely on grounds that they are unseemly or offensive are unconstitutionally overbroad. This is the abstract idea doctrine. So the federal courts threw that out. They did the same thing to University of Wisconsin law. Same thing, 1991, U.S. District Court threw it out. Suppression of speech, even where speech's content appears to have little value, amounts to governmental thought control. These are elaborations of the free speech jurisprudence of the Supreme Court in that period I just discussed. Another college case articulated in different ways from Shippensburg University, also thrown out in 2003. Temple University, a sexual harassment regulation, very similar. Supreme Court threw it out as overbroad. Not the Supreme Court, a district court. Court of Appeals threw it out as overbroad. This is a consistent pattern. Colleges and universities develop these speech codes. Someone took them to court, and the courts consistently threw them out under the jurisprudence that I just described. Here's another one from the city of St. Paul. It's not a university. Rules that governmental restrictions on speech must be content neutral. Now, governments can prescribe time, place, and manner of a speech, but they can't regulate the content according to that jurisprudence. So here we have a kind of a collision going on between the jurisprudence of the federal courts on the First Amendment and these other efforts to suggest that speech ought to be suppressed for various reasons. We've seen what the United Nations has done. We've seen what the European Union has done. We've seen what various colleges have tried to do. Here is the American College of Physicians. Just last year, it wants to claim that free speech is a public health issue because, you know, some speech can be hurtful to people. So can you suppress speech because it might violate public health. A strange idea, I agree, but it suggests that there are a lot of people in American society that are suspicious of free speech. Of course, you could ask the question, well, what the heck is hate speech? Let's have a definition that could be applied consistently, which is difficult to do. This is Laura Kipnis, a professor at Northwestern University. This just happened a couple of years ago. A very interesting story. That's the language of so-called Title IX of the Civil Rights Act of 1972. Pretty simple, but it's been elaborated in various ways. So Laura Kipnis is a professor. One of her colleagues was charged with sexual harassment, I think in her department. And she didn't think that the facts bore this out, and she wrote an article in the Chronicle of Higher Education saying that this sort of thing has gone too far and that a climate of intimidation is taking place on the college campus. This is an essay she published in the Chronicle of Higher Education. Some students and faculty at Northwestern University brought her up on charges for publishing that essay because in publishing that essay, she was creating a hostile environment for women on the Northwestern campus. The president of the university published an article in the Wall Street Journal more or less defending her. He was also charged with violating Title IX of the Civil Rights Act by creating a hostile environment. Now, in both cases on the basis of essays they wrote in national publications. There was investigation to both of them. They were eventually exonerated. But nonetheless, investigations were undertaken of these professors, including the president of the university at Northwestern. And this took place in, I think, 2015. So, what's going on here? Obviously, you've seen a lot of these statistics about the university moving to the left beginning in the 90s. I suspect it goes back further, but that top line suggests in a survey taken by the Higher Education Research Institute a few years ago that fully 60% of faculty members at major colleges identify as left and liberal. Only around 10% is conservative. So that kind of gives a flavor of the environment on the campus as to where some of these movements are coming from. When the faculty and administrators are overwhelmingly liberal, we're back to this problem. When we're out of power, we're for free speech, but when we're in power, we look at things a little bit differently. Should First Amendment protect hate speech? With hate speech not being defined, this is a survey taken a couple of years ago. So the conservative students think that the First Amendment largely should. But the liberal students say something entirely different. Very interesting, I think. You see 65% of the very liberal students say no, 60% of the very conservative students say yes. So this kind of indicates that the speech wars have kind of reversed from where they were in the 50s and 60s. It's no longer the conservatives who are suppressing the liberals, but the liberals who are now skeptical about free speech. This is another iteration of the same idea. Students were asked a few years ago, what do they think is more important, a diverse, inclusive society or the protection of free speech? And you get the same kind of breakdown between liberals and conservatives, with students in general being pretty much divided. I sort of wonder why is a diverse, inclusive society antagonistic to free speech? I mean, that's not obvious to me why that should be the case. The civil rights movement would not have happened if there had not been free speech and free expression and ability to oppose the laws that were existing at the time. I would think that people aware of that would be, cognizant of the importance of free speech. But I think that these figures suggest that a new conception of the university is developing, that really the university ought to be a diverse and inclusive community, and that's goal number one. This old idea that free speech and free expression is ideal number one is somewhat going out the window in the conflict between these two visions of the university. The university is a place where individuals explore the truth and express their mind. That's one vision. The idea of the university should be an exclusive place where free speech can harm some students. That's another vision, and these are somewhat in conflict, on the way somewhat to being resolved. All these events in recent years led to the University of Chicago articulating a view of free speech and free expression, very similar to the Yale Woodward Report in 1974. And many colleges have adopted this. Purdue University has adopted it. Princeton has adopted it. There are a dozen or so that have adopted this. Bernie Sanders, I think people have a right to speak. And you have a right, if you're on a college campus, not to attend. And he goes on. Bernie Sanders articulates a pretty good point of view there, in my opinion. Barack Obama, similarly, a couple years ago. You don't have to be fearful of someone spouting bad ideas, just out-argue them. That's John Stuart Mill. We know Robbie George and Cornel West at Princeton. Cornel West is a socialist, Robbie George is a conservative. They get together and argue and debate in front of the students, and they issued a statement saying that there should be a wide berth of freedom of expression on the college campus. There's a lot of model legislation around the states about public universities and how freedom of speech and expression should be protected on the college campus, usually with leaders speaking up forcefully to defend the idea and disciplining students or faculty who interfere with free expression. So, you know, Donald Trump, we got Donald Trump in 2016, I think, in part in reaction to a lot of the political correctness that was going on the college campuses. The Yale Halloween incident was very prominent in the minds of a lot of people. And of course, he campaigned against that. And I think lacking that environment, we might not have gotten Donald Trump as president because he just won by a small margin. Charles Murray's written this book, American Society Coming Apart. The two parties don't like one another. The two sides of the culture wars don't like one another. People live in their different political environments, listen to different news, read different newspapers, can't communicate with one another, use different language. America is totally divided. That would appear to be the case. He gives some sociological reasons as to why that's happened and how it's evolved over 30 years or so. So back to the Constitution. So you've heard this story about Franklin Roosevelt, or not Franklin Roosevelt, but Benjamin Franklin, on the day the Constitution was approved by the Constitutional Convention, where it's asked, what kind of government do we have, a republic or a monarchy? And he says a republic, if you can keep it, which is obviously the challenge that every generation faces. Madison says, if there is no virtue among us, if there be not, we are in a wretched situation. No theoretical checks, no form of government can render us secure. To suppose that any form of government will secure liberty or happiness without virtue in the people is a chimerical idea. So we've come to a point 200 odd years later where you have the Constitution. It's not clear we have a lot of agreement or virtue underlying that to sustain the Constitution. So that's George Washington's rising sun armchair, where I think it was Benjamin Franklin said he often wondered, looking at that chair during the Constitutional Convention, is that the sun rising in America or the sun setting? And he decided that it must be the sun rising. And probably that was true. I think we could ask that question today. If someone asked me that question today, is the sun rising in America or is the sun beginning to set? You know, on some days, I suggest that the sun is beginning to set. So alarmed am I at some of the things that are going on in the United States. However, I do think that if we can remain maintain our fidelity to the Constitution and to the institutions that are set up under it, including that First Amendment that we've just discussed. And we can allow for a wide berth of discussion and debate in the United States, so that when we arrive at a conclusion, it will be on the basis of discussion, so that we don't hate one another when it's all over with. I think we can keep it going. But that's the question. Can we do it? And I'll leave you with the same question that Franklin raised. And that's all. Thank you.
Thank you very much, Dr. Piereson. We have about 15 minutes for Q&A. Questions, comments?
Go ahead, anybody.
Well, I'll go first. Give you a chance to finish. We have a new policy at Villanova that's going to be on student CAT exams. Not exams, I'm sorry, surveys. And it's a question, and it says this. Let's see if I can read this without my glasses. Please use this space to comment on the instructor's sensitivity to the diversity of the students in the class. For example, biological sex, disability, gender identity, national origin, political viewpoint, race, ethnicity, religious beliefs, sexual orientation, socioeconomic status, etc. Is this something, Dr. Piereson, that you think is something that's compatible with free speech? Is it something that we should accept as a good thing, so that we treat each other well? Or do you see any problems with this in terms of stifling expression ideas in the classroom at all? Or would you rather not answer?
No, I can answer. I taught at a university near here many years ago, and I never considered any of those things when I walked into class. My students were my students. I'm not exactly sure how you would teach, say, physics or chemistry or any rigorous discipline if you had to pay attention to that constantly. I'm not sure how you would do it. I'm not sure how you're supposed to follow that kind of regulation. Not sure how that would work. I don't know if there is an intention to enforce that, or whether it's boilerplate language. It is part of the new dispensation that I just discussed, this new vision of the university. I think it's reflective of that. One of the points I tried to make is that we have a liberal tradition of maximum freedom for the individual against the government, and that was incorporated into our jurisprudence and incorporated into the organization of our universities. It's helped to make our universities great, and that we're now evolving a different tradition, which is more of a collective tradition, which holds that something called inclusiveness is more important than free speech, and that we ought to organize the university around that idea. Now, I'm not sure what that idea means pedagogically, but I think basically it says that this old idea of free expression and academic freedom is not quite as important as it used to be. Yes, sir?
The left speaks about inclusion. They're referring to sex and to race and nationalities, but not to ideas of conservative and liberal.
True. Yeah. They don't regard that as an important part of inclusion. That's back to that idea that I have, which is that when you're out of power, things look different than when you're in power.
Yeah, I bring it up all the time when there's an argument on this, and then I get tremendous pushback on this thing.
Yeah, I mean, I've always found it a paradox because when I was debating this, I usually don't debate this anymore, but because I lost all the battles, they're like you. But so they would say we have to hire people on the basis of various things: sex, identity, race, ethnicity, various things. And so I said, well, okay, why don't you hire some conservatives to balance out all the liberals? Oh no, we only hire people on the basis of professional competence. That doesn't, none of this has anything to do with it. So it's a kind of a bait and switch. On the one hand, it's something other than professional competence. But when you bring this up, we're back to professional competence. Look, it's one of the problems. Now, it would not be a problem. It would not be a problem if professors left their political viewpoints outside the classroom. So, if all the professors were communists and they were teaching physics or whatever, if they left that aside and taught it honestly, it might not matter quite so much. But the problem is the university has been so deeply politicized that every subject has now become political. So you can't leave the politics out of the classroom. It gets absorbed into everything that's taught. Now, I think you can raise a legitimate question as to, really what happens to America after we go through this kind of thing for a generation or so. What happens to our universities? What happens to our scientific research? What happens to our education about the Constitution and American history and so on after we've done this for very long? Do we eventually lose any common ground that keeps us together as a nation or a society? That's the reason I say when I look at the sun setting or the sun rising, I think there's a very good chance the sun is setting, because a nation at the end of the day, for any of its institutions to work, there has to be a common agreement to follow the rules of the institution, and there has to be some common assumptions about what kind of country we are or what we're aiming for. We can debate it and fight it out and so on. But if we're divided into a bunch of identity groups that dislike one another and are fighting for power, we're not going to be able to keep it going. Now just think about the separation of powers. That's your area. So Madison and the separation of powers. And we've evolved various things, like we had the filibuster in the Senate, which we seem to be in the process of getting rid of. Well, it seems to me that the checks and balances and the conflict that we build into the Constitution and the filibuster only works if we have a degree of agreement. If we have no agreement, I'm not sure these things work at all. In other words, checks and balances build a kind of a conflict into the governmental system. And the filibuster means that you can't suppress, you have to have an overwhelming majority to get anything through the Senate. But it turns out that the whole thing won't function at all unless there's some agreement that will allow you to get something done. If the two parties really hate one another, dislike one another, and are widely far apart, nothing can happen. So, okay, they got rid of the filibuster in the Supreme Court. All right, so it's just majority rule. Why did they get rid of the filibuster? Because they saw we're never going to be able to put anybody on the Supreme Court again, because we'll never get 60 votes for anybody. So we have to go back to majority vote. We don't have enough agreement in the country to have supermajority rule. So let's get rid of the filibuster. So the filibuster is still there for legislation. But that's going to go too. So Obama had to get 60 votes in the Senate, and he had it for a brief period of time to get his health care bill passed. Well, unless one of the parties has 60 votes in the Senate, they're not passing anything. Unless they can find some way to get it through, like they got the tax bill through last time. So I think it's a long way of saying that in order for this Constitution to work, the rules that we have, we need much more agreement in our country than we have today. And I think they're just going to stop working. And that's more or less what I would expect. Then you can ask yourself the question, what happens when they stop working? People will find other ways to get things done. Now, obviously, I think that's one of the reasons why the executive and the courts have become so powerful. All you need is 5 members of the Supreme Court really to change the direction of the country. You need 60 votes in the Senate to do anything. So that's one of the reasons the courts have seized so much power, because the Congress is paralyzed. And also the executive branch. So the Congress passes general laws, And the president and his appointees now interpret them very flexibly and do whatever they want. Because otherwise, if we relied on the Congress, nothing would ever happen. So these are things that we've done. But as you proceed down that road, these other avenues stop working too. So the Supreme Court has basically stopped working. We'll see what happens here. But the two parties, one party said, or maybe both parties said, we can't let you get control of the Supreme Court because you can change the whole nature of the government with 5 votes on the Supreme Court. We can't allow you to do that. And we have to do everything in our power to keep you from doing that, including breaking all the rules for the appointment and confirmation of Supreme Court justices. It's too important. We can't have a situation where 5 people can change the direction of the country. So that's going to break down. And when that breaks down, then I don't know where we go. And, you know, we have investigations of the president and so on. How's that going to work out? We elected a president and we're trying to get rid of him right away. So the United States is beginning to enter banana republic territory, where we're tossing out presidents and we can't appoint people to the Supreme Court and the Congress can't get anything done. And the two sides hate one another. And we're going to have a situation like you see on television, where the legislators get into fistfights with one another in some of these other countries. It happens in Japan all the time. It happened in the United States with Preston Brooks. I showed you that. Could easily happen again. I can easily see it happen again. After Preston Brooks beat up Charles Sumner on the floor of the Senate, all the members of Congress began to bring sidearms into the Congress to defend themselves against something like that. Obviously, that's a bad situation. But we could go there again if we wanted to. Now, we had this discussion over lunch. What the heck are we fighting about? What is underneath this that's leading these two parties and two sides to be so violently antagonistic to one another? What are we fighting about? And in 1860, it was very clear what they were fighting about. It was slavery and what all that meant and so on. That was pretty clear. But what are we fighting about now? And I don't have an answer for you. I can hypothesize, but this seems to be silly to me. In a country that's as prosperous as ours, that has as much freedom as ours has, that has so many avenues for achievement and expression and so on, that is as successful and powerful as ours is, why are we fighting like this in Washington? It seems paradoxical to me that this should be happening. A country with very few problems should not be fighting. Now then you can say, well, okay, well that means that nothing bad is going to happen. Well, as I said, again, we said over lunch, World War I broke out with no real precipitating causes. European civilization was doing just fine in 1914. Yet they had a war which destroyed European civilization. So very bad things can happen without significant precipitating causes. And that's what I worry about, what's happening in America today.
Well, please join me in thanking Dr. Piereson for being here with us.